nullification prevent. Now, let me go further on this. Our friends at the National Constitution Center, nullification is the constitutional theory that individual states can invalidate federal laws or judicial decisions they deem unconstitutional. And it has been controversial since its inception in American history because the Constitution doesn't provide for nullification per se. Now, that said, this is even worse than nullification than we've seen in the past, nullifying federal laws. This is a nullification in the strict sense of the term within the prescribed sphere as the constitutions of the states are within their respective spheres, but with the obvious and essential difference that being a compact among the states, that is the Constitution, in their highest sovereign capacity, the states adopted the the Constitution, and constituting the people thereof, one people for certain purposes. That is, you're a citizen of a state, but you're also a citizen of the United States under the federal Constitution. It cannot be altered or annulled at the will of the states individually, as the constitution of a state may be at its individual will. In other words, a state constitution or a state legislature cannot nullify the nature of national citizenship that was adopted by states. By states. These amendments later we'll get into. It's worse in this case of Manhattan because the state as an entity is enacting. It's a piece of the state. A small piece of the state, one judge and one prosecutor. So it's worse. He says between these different constitutional governments, the one operating in all the states, the others operating separately in each, with the aggregate powers of government divided between them, it could not escape attention that controversies would arise concerning the boundaries of the jurisdictions, and that some provision ought to be made for such occurrences. A political system that does not provide for a peaceful and authoritative termination of current controversies would not be more than the shadow of a government. The object and end of a real government being the substitution of law and order for uncertainty and confusion and violence, which of course is exactly what Bragg and Mershon have done in their courtroom. Not the state legislature, not the governor, two people. He goes on, quote, that the Constitution and the laws made in pursuance thereof, and all treaties made under the authority of the United States shall be the supreme law of the land. Two, that the judges of every state shall be bound thereby by anything in the Constitution and laws of any state to the contrary notwithstanding. Three, that the judicial power of the United States shall extend to all cases of law and equity arising under the Constitution, the laws of the United States, and treaties made under the authority thereof. Well, the issues that took place in that courtroom arise under the federal Constitution, which is why Joe Biden, an old Confederate who supported racism and segregation, opposed Brown versus Board of Education by opposing the integration of our public school systems. That's why he got up and said, this is a state court issue. No, it happened in a state court. That doesn't make it a state court issue. Madison goes on. He says, with respect to the judicial power of the United States and the authority of the Supreme Court in relation to the boundary of jurisdiction between the federal and state governments, I may be permitted to refer to the 39th number of the Federalist for the light in which the subject was regarded by its writer, meaning him, he wrote it, at the period when the Constitution was depending. And it is believed that the same was the prevailing view then taken of it, that the same view has continued to prevail, and that it does so at this time, notwithstanding the imminent exceptions to it. He said, there is no nullification right under the Constitution, period. And what I'm saying is what took place in that Manhattan courtroom was the nullification of a part of the Bill of Rights and the 14th Amendment, one of the Civil War amendments. Finally, he says in part, what the fate of the Constitution of the United States would be if a small proportion of the states could expunge parts of it, particularly valued by a large majority, and have but one answer. And he meant by that a civil war. That's 1830. He could see it coming. In 1834, he wrote a long treatise on this, December, about nullification. And I'm not going to read it to you in full, but I'll read one section. It follows from no view of the subject that a nullification of a law of the U.S. can, as is now contended, belong rightfully to a single state as one of the parties to the Constitution, the state not ceasing to avow its adherence to the Constitution. A plainer contradiction in terms or a more fatal inlet of anarchy cannot be imagined. You said that New York's part of the United States of America. It signed on to the Constitution. It can't now say, okay, but as far as the due process rights go in modern times, we're going to allow Mr. Bragg, Mr. Mershon to have their way, to basically eviscerate it and nullify its application.